going to ask counsel, I know who you all are, but there are a number of people in the gallery, and I think if you speak, while most people in this room know who is present, who will appear, just for the record, Mr. Harris, you start, introduce anyone at the table that you would like to introduce, and then I'll record it.
Thank you, Your Honor. My name is Bert Harris with the firm of Swain & Harris. With me is Danielle Brewer, an attorney in my firm, our firm, and Vanessa, who is chairman of the Hardy IDA. Bill Lambert, co-plaintiff, sits on the front row as well.
Thank you, sir.
My name is Henry Coleman, and I'm a defendant in this case.
Donald Samuels, a defendant in this case.
Dan Gerber on behalf of Clifton Larson Allen.
Robert Peterbaugh, attorney from Lakeland, Florida, representing Kerosene, with my partner Steve Sand.
We believe at this point, based upon the facts that we presented, the discovery that we presented, is that since the records, since the information and the records that were provided to CLA by CareSync that were used for the examination audit, since those records were never affirmed as being complete, accurate, truthful, and free from fraud, they were never affirmed as such by either side, either the private side, CareSync, or the public side, Mr. Lambert or Chair Hernandez, since December of 2014, with all of the efforts by CLA over that entire period of time to include at least 2 separate attempts with the various versions of letters to get these parties to finalize that report. The conclusion that, and on September the 15th, this last month, CLA appeared for the first time before the public and the IDA board, who had no idea why that was only a draft audit report from last December, found out for the first time on videotape that neither side will sign that report as being true, accurate, complete, and free from fraud. That tells us that our public records request from January, all of the requests from January of 2015 are meaningless, because we cannot depend upon those records that we received, or the state can't depend upon the 95 pages that they received as being complete, truthful, and free from fraud. So at this point, based upon that discovery and the fact that CLA did not inform the board or the public in December, January, or February of this past year, while all of that information about that examination report was being presented to the board and the public, while the grand jury sealed presentment was sitting there and had already been delivered to Ms. Hernandez, Lambert, Evers, Thompson, Bond, and we think up to 10 people. They had all that information, and that presentment corroborated the information in the examination report that they were using and had prepared their reasons and excuses that they used to get that board to exonerate and forgive hundreds of thousands of dollars in questionable expenses in the examination report and give Mr. Bond a free ride in December of 2015. And that was the reason why the examination report was declared a draft and was never revealed to the board or the public. And they knew that. And so our public records request in January, we thought it was a draft report because it just hadn't been approved yet by the board. This lawsuit, if you look at the complaint and the arguments, the stipulations that were used by the plaintiffs, they're saying that that report has never been finalized. They're using that as an argument for not releasing those records. They're saying that report has never been finalized, so therefore those are not public records. Now we're finding out the reason it's never been finalized is they refused to sign the affidavit declaring that that the information they gave that was used in that audit was free from fraud. I have the representation letter, Your Honor, that has never been given to the board. Mr. Samuels is an IDA member. He's never seen it. So our legal basis is that the declaratory decree cannot go forward until these records have now been impaired and encumbered. We cannot go forward until those records are cleaned up. We have to work with solid evidence, a foundation. It's analogous to sending a tax return to the IRS with a $7.25 billion deduction on it and not signing it. That's what it is. So we have an examination report based upon CareSync records that they claim are confidential that has never been signed. An $80,000 one-year audit that no one will sign. And CareSync, and CLA, they knew that. And they were working behind the scenes for 10 months with a plaintiff and CareSync to try to get them to work out a letter that they would sign and still keep CLA's credibility as a CPA, and they couldn't do it. And they finally reached their limit, and they demanded to be on the agenda on September the 15th, and they sat at that table and they made a statement that we've given up. And they said, likely, and it's on videotape, likely Mr. Bond will never sign. He will never sign this representation letter, and Mr. Lambert and Chair Hernandez, they still refuse to sign it because it makes them finally put in writing something, because they never put anything in writing. That's how they played the game. Everything is verbal and no records. This is where they finally got him in a corner, kind of like the deposition of Mr. Lambert on October 18, 2013, when he's finally put in a corner. They come up with pickup truck stories. That's my legal basis. We cannot continue until this bad foundation is cleaned up, Your Honor. Thank you.
Mr. Coleman, and thank you, sir. It's not whether what is in a document is true or not true, because the content doesn't matter. It's whether the record, electronic or in tangible form, whether the record is a public record. That is decoupled from content. The declaratory judgment action, the issues pending in this case are very narrowly, even though nonetheless significantly, even though they're significant, they're very narrowly limited to whether the records requested are public records.